Hi there. Are you ready for the first restatement? It gets harder from here. It's kind of like climbing a huge mountain. You look up at the mountain and you're like, that looks like a lot, and you'd be right. So enjoy the trees and shrubs at the bottom because it just goes more complicated from here. So the first restatement is the easiest one, okay? Because all about what I keep saying, lex loci. I really just think it makes me sound smart. Do I sound smart? You know what I mean? Like if I were to come and be like, lex loci delicti, that's the law we're going to apply. You'd be like, she's really well read. Like, not really. So, the first restatement, all it really looks at is where something happened. And based on where something happened, that is going to be the law that we abide by and we follow. So the first part of the restatement is to look at the what. So, what field of law? So if we have a field of law like tort, typically it's going to be what's called lex loci delicti, which means where the injury happened. So if the injury happened in Utah, we're going to follow that law. We're going to follow Utah law. Now, what about property? So remember, property follows what's called the situs rule. Where is the site of the property? If the site of the property is California, Californians are going to say, let us govern the law that applies. You like right there? Cite us. Ha. So law of situs just says where the property is located, that's the law that's going to apply. You're like, wait, what about personal property? Technically, it applies to personal property as well, where it's physically at. And that's going to come up more if you have like a wills issue. So say somebody passes away in Florida and they have a will and they leave you something that's located in Virginia. The law that's going to apply to the property itself is actually Virginia law because that's where the physical item is. Okay. Now, you have contract. That field of law is going to be governed by what's called lex loci contractus. Now, that is fun, right? So that's really going to look at one of two things, either the formation or the performance. So they don't have to be the same. If you have a problem in litigation, specifically about the formation of the contract, like the terms of the contract or something like that, the warranty that's included in the contract, that's a formation issue. So in that issue, if we are in the first restatement, we're going to ask, okay, where was the contract formed? Where was it negotiated, right? Based on that, that location is going to be what governs. So if we have a contract that we talk about in California, that's going to be performed in Texas, but I have a problem with the terms that were in the agreement, and I have a problem with how we formed the contract from the beginning because I thought that the guy took advantage of me. And that's going to be a formation issue. In that case, what would govern? Lex loci contractus says where it was formed, which would be California, thus California would govern. Now, what about if there's a performance issue? It's the same thing. Where was performance supposed to be or where was it? So if performance was in Arizona, that's the state that would govern. So when you're looking at contract issues, you have to ask if it's a performance issue or if it's a formation issue. So it's like two steps, okay? Now, marriage is a little bit of a messy one. So marriage looks at one of two things, okay? First of all, where did they get married? Second of all, were they domiciled where they got married? Third of all, are we going to consider their marriage valid? Well, that just depends, doesn't it? So let's just say we have two people that are from New York. They're domiciled in New York. But they decide to have a destination wedding in Florida. It's lovely there, you know? So they have a destination wedding in Florida. And they followed all the rules that Florida has regarding the marriage ceremony, what it takes for it to be legal, what it takes to be valid in Florida. And the pastor that presided over their ceremony did everything they were supposed to. They followed the documents, they had the witnesses, they did everything they were supposed to. So then this lovely couple eventually goes back home to New York. 20 years later, if someone tries to say their marriage is invalid, what's New York going to say? Well, if New York follows the celebration rule, they're going to say, we will find that marriage valid if the celebration rule is met, which means if the couple that got married, when they got married, they followed the rules of the state where the marriage celebration was held. Now, what if there is no celebration rule? They don't typically say anything about it. So say in the fact pattern, they say there's no celebration rule. Well, generally speaking, a marriage that took place in another state, as long as they followed the right regulations of the state for their marriage, then every other state will recognize that marriage as valid. With, there are some exceptions, but generally speaking, if you get married in any other state, they're still going to find your marriage to be valid. Now, some states use what's called the domicile rule, and that's just, if you have an issue with your marriage and you're getting married in New York and you're domiciled in New York and you follow New York's positive law, then your marriage is going to be held to be valid. So what is domicile rule? Domicile rule regarding marriage is if you follow the rules and regulations governing marriage in the state where you're domiciled and you did get married in that state. So if you live in a specific state, you and your spouse, and you get married in that state and you follow all the rules in that state for the marriage to be considered valid, it will be held to be valid because of the domicile rule. Like, you live there, you do what you're supposed to. Positive law, literally all it is the rules and regulations that govern the marriage. It's called positive law. So if you follow the positive law of that state and you're domiciled there, then the domicile rule says your marriage is valid. Now, celebration rule, if you follow all of the positive laws of the state that you got married in, even if you weren't domiciled there, then the celebration of the marriage and the actual marriage itself will be held to be valid everywhere. That's supposed to be how it works, right? Now, you didn't think I let you get away without any exceptions, did ya? So, and just so you're aware, domicile rule technically is section 132 if you want to know numbers. There is an exception actually to the celebration rule and the domicile rule, and the exception is section 134. Section 134 states that if the marriage, even though it should be held to be valid or is valid because they followed positive law under the domicile rule or under the celebration rule, enforcing or recognizing that this marriage is valid is so egregious to us because it breaches and violates fundamental state public policy. It's so awful that we refuse to acknowledge this marriage because of this fundamental public policy that this marriage is violating. We do not have to recognize it. We do not have to validate it. That's what section 134 is stating. So that is the exception to the domicile and the celebration rule. Is you might say, oh, marriage is valid everywhere if I did everything legally, not illegally. If I did everything legally, but 134 says no. If I get married, say in New York, and we move to Florida, and Florida is like, your marriage was so egregious, it breached so many fundamental public policies of ours, of our state, we're not going to recognize your union. Let's say, perfect example, let's say I get married in New York to this lovely, amazing man, and he's a foot taller than me, okay? And I move to Florida, followed by this very lovely tall man. And this very lovely tall man and I try to, apply for something as spouses. And they won't recognize it, so we go to court to get our marriage recognized in Florida. But Florida has a state public policy that says no spouses ever, or no people will ever marry someone that's a foot taller than them or a foot shorter than them, ever. If there's a foot distance between the two of you, that marriage will never be considered valid because it's so egregious to us, it's so awful to us, it makes no sense, it's against our law, and it's against public policy that's so fundamental to who we are as a state, and we just refuse to ever allow this. So, in that case, even though the rule of celebration is fine, let's say we happen to be domiciled in New York at the time, say we meet celebration and domicile, we did everything we were supposed to do, the positive law was met in that state. However, under section 134, if it's so, egregious to the state that we're trying to go to or trying to have our marriage recognized in, they could say no, because states are not obligated to recognize another state's law if it's egregious or violates one of their fundamental public policies. Now, remember, public policy does not mean public policy for the entire nation. It's by the state, okay? So, a few examples of this that actually does come up is any type of issue with transgender marriage rights or same-sex couples or anything like that. That is the type of case that would probably come up. Or if there's a case of, say, incest or polygamy, those are cases that might come up and cause issues with different states because it's all by the state. So some states allow you to get, married or have a partnership if you're a same-sex couple, whereas some states don't allow it. Some states allow you to marry your cousin, while some states don't allow it. It just depends. So and here's the thing as well, when it comes to allowing or disallowing a marriage, if you're going to disallow a marriage because it's so egregious, then you have to have a law that's written. And that's kind of like a nuancy thing. What that means is, if a state looks at your marriage and they say, this violates a public policy, this violates a right of our state because we don't want this thing in our state, we don't want to recognize it, but there's no actual law that says it, then technically they cannot say this marriage is invalid for this reason if it's not written as a law somewhere. Now, you're probably like, I bet there's an exception to that, and you'd be right. So the exception to the exception is what's called natural law. So some states will use natural law to enforce the actual end result they want, or to enforce the result that they don't want, or that they're trying to get around. So what I mean by that is sometimes there will be a written law that says absolutely no incest at all whatsoever. It's egregious to our fundamental public policy according to 134. It's actually a written law. So technically they wouldn't have to recognize a marriage that took place in another state, even if it was celebrated by the state's rules, and they didn't break any rules in that state, and they moved to a different state. That state says under section 134, technically that's invalid because we have a law that says no incest is allowed. But then another judge could say, however, based on natural law, I'm going to allow this marriage to continue, and I'm going to deem it to be valid in this state as well. Natural law is the underlying meaning or inspiration of the marriage, okay? What was marriage created for? Perfect example is it created for the unity of two individuals, to make two individuals one. It was created to help bring children into this world, to create a family. Once you get married, now you're a part of a family unit, technically. And it was also created for originally between one man and one woman. So that would be an example of natural law. So let's say that we have a couple that are second cousins and they get married. And in New York, it's against the law to marry a second cousin. It's written in the law. It says there's going to be no incest at all, including cousins, right? So let's say these people get married in Texas. They decide to move to New York to chase a Broadway dream of being stars on Broadway. And these people are trying to get things done in their capacity as a couple, and they can't because New York says, even though the celebration rule was valid, we're not going to recognize it anyway because of our rule against incestuous marriage under 134. However, even though technically we could say we do not find your marriage valid, we are still going to allow it because the meaning and underlying purpose of marriage was to bring two people together for the purpose of making children, for the purpose of bringing people together as one, for the purpose of giving you a companion for the rest of your life to help you in sickness and in health. And clearly, that's what this relationship between you is. It was not done with the intention of breaking our laws. It was not done with the intention of being incestuous. It just happened to be incestuous. But at the end of the day, because of this natural law, we're going to allow this marriage to continue anyway because of the underlying meaning and purpose of marriage, the underlying value of marriage that we have. So it's almost like the state will take a position before a case proceeds. And they use these exceptions to try to get the result that they want. So for example, there was a case called Mays Estate where there's a couple, it was an uncle and a niece, and they got married. And they got married in another state, and they moved to New York. And their kids later sued, saying that the father should not be allowed to, distribute the estate of the wife, of the mom, because they had an incestuous marriage, which is illegal in that state. Therefore, their marriage was not valid and never was and never could be considered valid in New York. And so technically what New York did is they said, well, based on celebration rule, we should allow it. However, it is written in our law that we don't allow incestuous marriage. But, you know, the purpose of marriage is all these beautiful things. And these people were together for years. They went to another state to get married. They didn't do so to, you know, specifically act as a felon or specifically to violate the law. They got married there because that's where their family was, and they didn't think anything of it, but they weren't trying to evade the law. And they had children, and he cared for his wife as she died, and he cared for her and their children, and blah, 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 right? So what they did in that case is they said, no, we're going to find this marriage valid because of natural law, right? Even though our positive law, the laws that we created to regulate and govern marriage, don't agree, we're still going to use this exception to the exception to get around it, right? Now, the same thing happened in another case, but the opposite result. There's a case called Catalano where a couple, an uncle and a niece, got married in Italy. And they had a child, and then eventually they moved to the United States. And in this state, what happened is after only a few years, the husband died, and the wife applied for assistance from the state to help her raise her child because she didn't have enough money now that her husband had passed away. The state refused to recognize the marriage, and because they didn't recognize the marriage, they refused to give her the support of a widowed spouse that she would have been owed this was several years ago. And so what they used is they said, well, based on the celebration rule, it was allowed. However, we don't have to acknowledge the celebration rule if it violates a fundamental public policy of ours, which it does. And they stopped at 134. They said it's incestuous. It says on our positive law we don't allow that type of partnership. We don't allow that type of ceremony. Therefore, absolutely not. Won't allow it. They didn't use natural law, but if they had, they would have argued this way. They would have said it's between a man and a wife, not between an uncle and a niece. And even if they were a man and a wife, at the end of the day, there is nothing saying that marriage was created for family members. It was created for people outside of your family to create your own family. You see how I can take the same principle and twist it? That's exactly what the court does to try to get the result they want, especially in situations like this, okay? So just remember, you have the celebration rule or domicile rule, okay? That's based on where that person got married. Did they follow the positive law of that location? If they did, it should be valid everywhere or in the state at the very least where they're domiciled. There's an exception where they could say even if it should be valid, we're not going to hold it to be valid because of our law that we have says that's egregious. We won't do that. We won't accept it because it violates such a strong public policy of ours. That's section 134. Now, in the late 1800s, actually, in Utah, there was a huge constitutional case where there was a man that was trying to marry another woman, and he was already married, but that was part of his religious belief, right? And so his religious belief said that that was acceptable to marry somebody else, and if he did not do so, he would be violating his religion. And unfortunately, in that case, he lost, and that was a great example of how the court will take these policies and they'll implement them. And so in that time frame, polygamy in that state was illegal. It was a written law, and therefore he was guilty and criminally charged because of these things. And you have to look at the state law to see how they're going to be applying section 134 or what their positive law says. And if they find that a certain action violates their actual public policy, they don't have to, actually respect the marriage. And it's kind of crazy how that works. So be really aware of how a court can interpret things based on the law and how they want a case to end and how they want the conclusion to look, because that is going to affect further precedent. And a lot of times when it comes to states, they're going to choose what they want for that state, right? So it's just opinions aside about what you think of these things. If you want to know how to get to a result that you want, this is how. If you want to know how they get to these results that maybe you like or dislike, this is how they do so. They manipulate the rules to get the answer that they want. And that's just kind of how it works, right? Now, when it comes to that exception 134, think more state-based, but the most common is incest, polygamy, transgenderism, and same-sex marriages or partnerships. Those are the most common now, so think hot-button social issues, okay? Then you obviously have natural law, and that can go either direction. What is the underlying meaning and purpose of marriage, okay? Now, when you're looking at the first restatement, let's say We're going to jump outside of all marriage for a second. So let's just say the first thing we did is we discussed, okay, what's the field of law? We decided which one it was, handled the nuances of which one it was. Then we're going to ask ourselves a follow-up, okay, what rights were vested and where did they vest? Remember, first restatement is the vested rights approach, which means that they always ask what rights vested where. So, if you got married in New Jersey, the rights of marriage arguably would vest in that state where you got married. If you bought a piece of property in California that was located in Nevada, your property right vested in Nevada because the title transfer happened in Nevada. Even if you signed paperwork in California, the title was technically transferred in Nevada because it was now on their books in Nevada. This property is owned by you, right? Tort. Where did the rights vest with tort? This one could be tricky. If you're driving in Minnesota and you hit somebody else in Minnesota, easy, Minnesota. What if you're driving in Virginia and you're driving over this huge bridge that goes into Maryland and you happen to hit a pedestrian that was running on the bridge for some crazy reason. So you hit the pedestrian in Virginia, but the pedestrian flew 30,000 feet, okay, not 30 feet in the air and fell over the state line of Maryland. And that person needed emergency care. And, another car saw what happened, got out of his car and tried to save this woman's life, but she eventually died in Maryland. What state would apply? It depends what the suit is about, right? Typically, it would actually be Maryland because that's where she ultimately died. And even though the tort started in one state, it ended in another. So where was the finality, I guess, of the tort is a good way to look at it. But you could also look at potentially the type of claim, because she might claim, say that she didn't die, or even if she did die, her estate could claim two things. It could claim assault and battery and wrongful death. So you're like, well, technically the assault happened and battery happened in Virginia, and then technically the wrongful death happened in Maryland. So you can separate sometimes a case. There's actually a doctrine for that. Not going to get into it because most of the time it's not discussed, but if you could separate two doctrines and apply two separate laws depending, I believe it's called, I can't pronounce it, it's a French word. It's like discernement. It's a French word, starts with a D. It pretty much means you divide a case and their issues based on the law that would apply. Very nuanced, doesn't really happen too often, but if it were, that's when it would come up. So, what's the first thing you ask? What law is it that we're dealing with, right? How are we already characterized it way earlier on. If you are following the Eton way method, you already characterized it. Now you have to ask a little bit further. You have to go a little bit more in depth to establish what exactly is going on for this field of law specifically. Then you have to go into their nuance, and then you have to say, where did it vest, right? Where did these rights actually vest? And that's pretty much the gist of just the first restatement. You still have to finish the analysis with the last step. That's going to be a separate video, but that's the gist of the first restatement.